Mr. Chief Justice, and may it please the court, my name is Matthew Sease, and I represent Tim Erpelding in this matter. Today we ask that this court reverse and vacate the Court of Appeals opinion and specifically affirm the district court's denial of Jodi's request for attorney's fees in this case, affirm the district court's alimony award, and reverse the district court's child custody determinations. I'd like to start with the attorney's fees issue first. The Court of Appeals ruled that it is per se a violation of public policy to have a premarital agreement that waives attorney's fees. And I think before you can get into a full depth analysis regarding that, I think it's important to keep in mind what is actually required for a court to find a violation of public policy. And this court has said on numerous occasions that there needs to be a finding that the contract provision is so bad that it violates the general public welfare. And in order to make that determination, there needs to be a constitutional provision that's being violated, a statutory provision that's being violated, or a prior decision of this court or the Court of Appeals that's being violated.
We have a.
What about if we go?
Go ahead.
What about it? I mean, what about if we put aside public policy and just look at the language of the statute? The statute says that the rights of a child to support shall not be adversely affected by a premarital agreement. Now, can't one argue that where a premarital agreement bans an award of fees that might otherwise be available for litigating child support, that adversely affects rights to child support, without getting in all this public policy and that sort of stuff?
I agree somebody can argue that, but I disagree with that interpretation of it. And I specifically disagree with it because that provision in the statute, and what the statute actually reads is that the premarital agreement shall not affect the right of that individual to get, or the child to get support. And so what we're looking at, and I think what that provision is actually pertaining to, is saying that the premarital agreement shall not say, I'm not going to pay child support, or spouse is not going to pay child support. And that's what I think that the true intent of that statute is. And if you look at the other states, and I think we've cited the South Carolina Hardee decision that says that the majority of these states have said that you can waive attorney's fees in that. And in fact, in the most updated version of the Uniform Premarital Act, which I don't believe Iowa's updated yet or has adopted, but we cite in our briefs, the model code specifically talks about the ability to waive fees, but I think it also has similar languages that it talks about that you shall not affect the ability or adversely affect the ability of the request for child support within the premarital agreement.
But do you completely reject out of hand the notion that if a spouse either can't afford to hire an attorney and experts, or is at a substantial disadvantage in her ability or his ability to pay for those kinds of expenses, that this doesn't adversely affect the issue of child support?
I think that that's true, because one thing to keep in mind is this court, through the adoption of the rules of civil procedure and as they specifically relate, there are all of these requirements when you're talking about child support that have to be done. You file their financial disclosure documents and saying what each party certifies is their net worth and their finances and all that type of stuff. And when that's out there and that's being submitted to the court, you don't really necessarily need attorneys or experts to make that determination, because at the end of the day, the child support, which is what the statute actually says can't be affected by the premarital agreement, is a somewhat easy determination, and it's just plugging in the numbers into the formula and coming up with it based on the requirements of what has to be disclosed within any custody determination. So I don't necessarily believe that it really affects even the most indigent of individuals to have this preclusion in there. But even if you are to rule that there are instances, such as what you were suggesting, Justice Hack, that there are certain cases where it could be affected. And I don't think that you have to make that determination in this case. And this goes to what the Court of Appeals ultimately rejected, was our argument as an alternative argument of whether it's voidable or whether it's per se void. The Court of Appeals ultimately ruled that it was per se void, and I think that that's improper for several reasons. First, they relied extensively and quoted extensively a case out of Colorado, and in that case, the court said a waiver of attorney's fees violates public policy where one spouse lacks the financial resources to litigate the dissolution. So what I believe the court in Colorado is saying is it only violates public policy when you have somebody that can't actually litigate the case because they're indigent or don't have the financial resources to do that. And in this case, you clearly don't have that situation. Jodi was awarded over $800,000 through the district court's order in this case. A majority of it, nearly $400,000 of it, was liquid, including $250,000 that was cash paid out in this case. So,
but that comes at the end of the case after the issue's been litigated, right? So I mean, wouldn't we, even under your position of voidability, wouldn't we have to look at the financial condition of Jodi at the beginning of the case rather than at the end?
well, at the beginning of this case also, there was a request for attorney's fees, and it was outlined as far as Jodi's assets, she had over $150,000 at least in a 401k, and I think that Tim had already purchased the house for her that she got without a mortgage. So I think in this case she even had enough at the time. But I don't think that that's necessarily accurate either, because every divorce case, you can ask for temporary attorney's fees. There's no doubt about that. But a majority of the fees in what you're seeing are getting requested is at the end of the proceedings. And I think in practice, I know from family law attorneys that they're getting the money and they're getting paid through the property distribution or through whatever alimony that's getting deducted or paid or whatever. That's how it's in actually a lot of these attorneys. They're treating it like a true contingency plaintiff's case, I believe. And so I don't necessarily believe that the decision needs to occur at the beginning of the case. I think you have to look at the end of the case. And in fact, another problem with the Court of Appeals' ultimate decision is the standard that this court has established and the Court of Appeals has adopted on a continual basis is the reasonable ability. You only award attorney's fees if there's a reasonable or no reasonable ability to pay on behalf of the party that's requesting it. And so when you need to make that determination, once they submit an attorney fee affidavit, the court needs to look to, is there a reasonable ability to pay these attorney's fees? And in this case, with Jodi getting almost over $800,000 and well over $250,000 in liquid funds, she absolutely has a reasonable ability to pay those attorney's fees in this case. And so I think that's another area where the Court of Appeals erred in that they just ultimately said, we're going to find that this per se violates the public policy of the state of Iowa, that you can never waive this. And so we're remanding to the district court for determination of fees related to child custody issues, and we're going to award appellate attorney's fees as it relates to child custody issue with no analysis whatsoever as to Jodi's reasonable ability to pay.
So, counsel, you would interpret 596.5 2, the words adversely affected, to essentially mean that a party cannot waive child support in a premarital agreement, waive it altogether?
Exactly. That's my belief of it, and it's because of the first part of that sentence where it says the right to child support, and it cannot affect that right. And by no ways does it affect, by waiving attorney's fees, affect the ability of the individual to come to the district court and say, I need child support. It in no way affects the ability to ask for spousal support. It just says that the costs of doing that request are going to be related to whatever party is, each party's paying their own, is what the...
In the absence of counsel for either party to a case, in your view, as a matter of law, has no adverse effect on child support.
I believe that that's correct. I believe that that's correct. All that's being waived is the right to request attorney's fees in this case, and within the contract. And so, if that's all that's being requested, then I believe that it is not a violation of public policy, and it is not in violation of that statute, because I don't believe it's adversely affecting it in any way.
I want you to talk about the alimony a little bit. When I was on the Court of Appeals, I heard the complaint, you guys on the Court of Appeals, you tinker with alimony. And
Yeah.
Court of Appeals, for want of a better term, adjusted the alimony upward.
Yeah.
And you're objecting to that.
We
So-
are, and we outlined the math in our application for further review of what we think the problem is with that. And essentially what the Court of Appeals did is they increased the alimony by $500. We had the district court who sat through it and listened to everything about these parties' finances and made a decision that the alimony was $1,166 is what was the rightful alimony. The Court of Appeals tinkered with that, to use your term, and awarded $500 without any real justification that I can see in there to say this is why. And when you actually run the numbers, as we did in our brief, as of today, Jodi is actually increased, or has a monthly allowance that is higher by over 10% than what Tim's is. And when the oldest child moves out of the house and turns 18 and child support custody goes out, as it relates to him, the alimony, or the child support, actually increases by several $100s, and I think it's going to tick it up to almost 20% greater that Jodi is collecting on a monthly basis, more than what Tim is based on that. I think there's also, I think you can read into the Court of Appeal, or the district court opinion, that there was a recognition that at the time of the decree, Tim's income was on a significant downturn because of the farm value of land was going down, and the crop prices were going down as well, to the point of when he was actually arguing this case and trying this case in 2015, he had a net loss of over $150,000, where in 3 or 4 years earlier, he had a net gain significantly higher than that. So the downturn of that, and I think that the district court recognized that in setting the amount and income that they did of $125,000 for him. Just briefly as well, I would like to mention the child custody issue before my time runs up. This court has recognized that there's a presumption that the district court shall not separate two children. And the language and the rationale and the reasoning behind that is very clear. And in doing that, they've set 4 factors in place for making the determination when it would be appropriate to split the custody of siblings. And in this case, not one of them apply at all. The age of the children is only 4.5 years, so it's not a very large age gap. We don't have an 18-year-old and a 2-year-old. The children in this case have a clear bond. They also would have remained together but for this divorce. And the parental home and the home where the kids were both raised in is the family farm. And the clear place that they should have been placed was with Tim, and not gone against this, or not went with the split care arrangement. With that, I'd reserve the rest for my rebuttal. Thank you.
Thank you as well, Mr. Sease. Mr. Lips.
May it please the court, Mr. Chief Justice Cady, counsel. My name's Tom Lips. I represent Jodi Erpelding. We think the Court of Appeals decision should be affirmed. there's a couple of concepts here I'd like to talk about. One, of course, is the poll star. The district court and the appellate courts are supposed to determine what's in the best interest of the children. And the other is that the district court is supposed to do financial equity for the parties. And that requires a couple of things. Both parents have to have access to counsel, and also the district court has to have all the tools to do equity between the parties. We've all, heard the concept that when you do a divorce, you throw all the assets and liabilities into a pot and divide it up. When you have a prenuptial agreement, it takes a big part of it out of the pot that the district judge can't work with, and that's the property settlement. And that's what happened here. The remaining issues were child support, alimony, and attorney fees. And this was a very expensive case to try. It was an 8-day trial. We got our evidence on it a day and a half, but it
Did seem like a lot of the trial related to whether the prenup was enforceable or not, right?
part of it was, part of our case was, but, that went on and off fairly quickly. And our main argument, I think, was for reimbursement alimony rather than trying to avoid the prenuptial. I think I'm going to have to disagree with that. We didn't make that big a deal with the prenuptial. We thought it was unfair, but we were angling for reimbursement alimony. And I'm going to get to that later. We think the Court of Appeals should have awarded reimbursement alimony. So regardless of how the alimony was computed here, we think there should have been more alimony, whether it was reimbursement alimony or periodic alimony or however you call it, it was alimony. So we think that was right.
Counsel, on the attorney fees issue, Mr. Sease has essentially argued, forgive me for paraphrasing, but essentially that your client departed the marriage with roughly $800,000 in net worth, and so she would not, the issue of child support wouldn't have been adversely affected if she had to pay her own attorney fees. What's your response to that?
Well, I know what my response is, and I'm sitting across the desk from my client while the attorney fees are being racked up. And I think any attorney who ever gets involved in dealing on divorce cases, attorney fees are almost always in the forefront of these cases. How far do you go? How many witnesses do you have? One of the decisions we had to make here was whether we filed our own application for further review, because we didn't actually agree with the Court of Appeals in not awarding reimbursement alimony. But this thing, we asked that the Supreme Court take this to begin with and hear the whole thing. But it was, it was transferred down to the Court of Appeals. The Court of Appeals ruled on it. You got to look at the statistics as to how often these family law cases go up to the Supreme Court. It definitely affected what we did here.
I guess my, put another way perhaps, how would the interest of these two children and their parents with respect to child support have been adversely affected if you hadn't been involved in the case?
Well, to give credit to Jodi, it may not have affected this case. But this isn't the only family law case that happens in the courthouses. The jury trials are on the downswing. We have criminal cases. We have these family law cases. That's what's out there now. And, a lot of attorneys won't take divorce cases. They don't want to get involved in the emotions. They can't get paid. All kinds of things are involved for the same reason that a lot of district judges don't like to hear these cases. Now, that wasn't the case with Judge Carr. He's a very good judge. He listened to the case. It isn't an issue. But, these divorce cases are complicated. And the district court has to rely on the financial affidavits, the stipulations. There's a lot of work involved. And on top of that, the attorneys have to kind of be a referee for the parties. you know, this case is maybe the exception to the rule in that there weren't a lot of problems with visitation and whatnot. But, you know, often when these cases come in the door, you think, well, there's going to be a divorce, and before you know it, it's a 3-docket thing. There's a civil protection order, there's a criminal thing, and then there's this divorce case. And, you know, sometimes this happens. You know, the people call you up or they come in and see you. They find out how much it's going to cost. You know, they wonder whether or not they're going to have the money to pay a lawyer. They go out and take the law into their own hands. You know, they make a complaint, get a civil protection order, and file the criminal case. And so it becomes a problem when these people get frustrated on whether or not they can hire a lawyer. Now, all cases don't go like Jodi's here. We didn't have the civil protection order or a criminal case, but it's helpful to have attorneys involved to make sure the emotions are walked back, so you don't have this triple docket situation in these divorce cases. So, yeah, Jodi was going to litigate this to the end probably anyway, but there's a lot of tension involved. She's basically had to blow what would be her retirement to litigate this thing through to the end. And I think it has to be decided whether or not that's fair. If you look at the whole picture here, and it gets back to this reimbursement alimony part of it, Jodi they had an agreement at the beginning of the marriage. She had a decent job. She paid all the living expenses, provided the insurance, and all the non-deductible stuff she paid for. And the agreement was Tim would grow the farm. And, you know, we asked for reimbursement alimony. This wasn't this was a situation where he did grow his farm. He ended up with about $7 million, according to, if I remember the Court of Appeals opinion right. About half of that was inherited, but he ended up with a ton of money. And a lot of that was due to Jodi's efforts. She sacrificed her retirement. She didn't have a savings plan. And all that went into this farm that Tim ended up with. And, you know, I heard this argument again that he's got financial problems. Well, if he's got financial problems, it's his own fault, because his own expert took the stand and said the land up in Kasuth County, you could put it in the CRP or the wetland program for $345 an acre. The arithmetic shows he could do that. And at the end of the year, all he'd have to do would be endorse a $206,000 check from the government each year. So he's not having financial problems. He could sell his machinery, pay off his debt, pay the taxes. He could get a job in town on top of that. So he's not having financial problems. And those are some of the things that I think the Supreme Court could consider as far as affirming this, even though maybe all the Court of Appeals reasons.
But, I mean, his point is, all right, your client comes, you know, she has her job with IEA. She gets health insurance. He is going to have to go buy health insurance on the individual market. She gets it free through her employer. She has this $262,000 in liquid assets. She has a house free and clear. She has a pension, I assume, through her job. You know, and she also has whatever it is, $1166 that was awarded by a month that was awarded by the district court. So what, you know, that, where is there the sort of the failure to do equity, if we, you know, our standard being that we're supposed to give some deference to the district court in the area of alimony and alter it as an appellate court only if there's been a failure to do equity?
Well, the best I can answer that, Your Honor, she would have had a lot more had she taken her, if they would have split the living expenses or if Tim would have paid it, she'd have had a much greater pension plan. She'd had a much better savings plan. she cut back on her earnings. It affected her income track. It affected her pension. Yeah, she ended up with some money, but a lot of that money ended up in Tim's pocket. So is that fair? So those are the reasons. I thought the Court of Appeals didn't, although they rejected the reimbursement alimony part of it, I thought they did a nice job analyzing why she should get more money as far as regular alimony, and I really can't improve on that. And getting back to whether or not she can afford an attorney, yeah, she's going to get me paid somehow, but it's at the expense of basically her retirement, what she would have set aside for retirement. And I submit it should just be a bright line test. I can't improve on the Walker case from South Dakota that we cited. They have the Uniform Act on prenuptials, and I think in that case they said you can't prohibit awarding legal fees for trying to get alimony. I think that should be the rule here too. I think it should just be a bright line rule. You should be able to get attorney fees, at least on these protected areas, child support, child custody, alimony. Just make it a bright line test and then leave it to the district court to decide whether or not to award it. Otherwise, you got this two-step analysis all the time. It should, if it's just void, then you get back to the old rule that the court can make a determination.
Counsel, just for clarification, it's my understanding the argument in this case, though, relates to the attorney fees just for the child-related issues, right?
Right.
You didn't broadly address alimony as well, did you, or am I wrong?
We did at the Court of Appeals level. In fact, we cited that Walker case from South Dakota, and basically it was our argument, if you can get attorney fees for trying to get alimony, you certainly ought to be able to get it for child issues, because that's even more protected than alimony, in my view. So we did make that argument. And the Court of Appeals just limited it to the child issues and child support, the way I understand it.
How do you respond to the argument that the legislature could have been more explicit and said you can't waive your right to attorney's fees in a prenup, but they stopped short of that?
Well, they did stop short of that, and I can't improve on the argument in that Walker case. It just makes sense that if you're entitled to, if a prenup can't keep you from getting child support, I mean, you can't sell your kids, you can't contract your way to child support, you can't sell off your right to get alimony. You ought to be able to at least have access to counsel so you can enforce those rights.
How about the issue of the split physical care? We've used the language of presumptions, kind of a loose concept. I mean, there's about 15 different kinds of presumptions: bursting bubble presumptions, criteria presumptions, irrebuttable presumptions, etc. It's fair to say that the case law frowns, at least somewhat, on split physical care. First, what is your view of what the presumption is from a legal point of view? And then secondly, briefly, what are your strongest points in getting around whether it's a weak or strong or criteria-oriented presumption? But I'd like to probe that subject area.
I'd like to answer the last part of that first, in case I run out of time. The parties agreed that they should split them. They mediated that with ex-Justice Baker.
Well, that was a temporary arrangement, was it not?
It was a temporary arrangement, but then Tim asked for a guardian ad litem, which we resisted because we didn't want to keep running up the bill. And the guardian ad litem came to the same conclusion. Judge Carr came to the same conclusion, so did the Court of Appeals. So they all agreed. The short of it is, Derek's younger. He's 5 years younger than Billy. When a little over a year, Billy's going to be out of high school. You'll have Derek there home on the farm by himself, and he's attached to his mother. I think it was pretty well set out in the Court of Appeals decision as to why he should stay with his mother. I think maybe I'm over.
Right. Thank you, counsel.
Thank you, Your Honor.
Mr. Sease.
Thank you, Your Honor. May it please the court. I just want to address a couple of things. Justice Mansfield, I think you're absolutely right when you pointed out earlier that the case was long because of the property issues that were involved in this case. I tend to disagree a little bit in Jodi's interpretation that she didn't contest the prenup that vigorously. There was a lot of testimony about that, and Tim's whole issue and why the case took as long as it did was because Tim had to fall back and establish if the district court were to determine that the prenuptial agreement was invalid for any reason, he still had the ability to show that all of, or a majority of the items in which he was entitled to, he inherited throughout that process. And so if you look at the actual testimony over that 8-day time period, a significant amount of it was directed to, number one, that the prenup was valid, but number two, that a majority of those assets, and I think it was upwards of $4 million that Tim ultimately received in this dissolution proceedings, was actually assets that he would have inherited even if that prenuptial agreement wasn't in place to begin with. And so Tim was required to put on a case as long as he did, based on Jodi's contestation of the premarital agreement. One other thing that I think is important that I've not heard, except for maybe briefly today when they were discussing their further review application, but Jodi has never asserted throughout these proceedings that in any way her experience at the trial level was any way affected by the lack of attorney's fees or the availability of attorney's fees throughout this case. There was no experts that they requested to be paid for. In fact, the one thing that they could have been on the hook for was that guardian ad litem, and Tim actually was ordered to pay all of that, the fees associated with that. So there was no way, and they've never established or shown that they would have tried this case differently if they had been awarded attorney's fees or had knowledge that they would be able to get attorney's fees. But attorney's fees aren't a matter of right, and I think that's why they can establish that. It's a decision of whether or not they have a reasonable ability to pay that, and it falls back with she has a reasonable ability to pay. And then one other just brief issue, there was a mention about the CRP and that Tim could have generated significantly more income if had he enrolled in it. If you actually look at the testimony that's in the record that talks about that, it came out through cross-examination, and it was not clear that there was even CRP land available at that time. There was not anything that said that this is what the going rates are, other than, yeah, this sounds about right, around $340 an acre. But there was no indication at all that that was an actual true available income for Tim. What the district court did is he just said Tim could cash rent this out at $275 an acre for, I think it was like $148, but that's again depending on the market, or $148,000 a year, but that's again depending on the market. So just to refresh, we are asking that this court affirm the district court's award or denial of attorney's fees, the award of alimony, and we're asking for reversal of the district court's split care determination. Thank you.
Thank you as well, Mr. Sease. The case of In re the marriage of Jodi and Timothy Erpelding is now then submitted, and the bailiff may adjourn.